review professional responsibilities overview, and problem with this is that I don't have it ready. So let's see. To pull this up, it shouldn't be too long. It's kind of redundant when you look at how many videos I have in this section, just like introducing the topic. Regardless, where is it open? Oh, this is California. So this is a little bit special. California Professional Responsibility Overview. This is a 14-page outline. In brief, lawyers are subject to various sources of ethical regulation, and lawyers who violate these rules may be subject to discipline. This overview focuses on the ABA model rules of professional conduct and the most notable California distinctions. Part 2, regulation of lawyers. When is a lawyer subject to discipline? Violating the RPC or assisting others in doing so. RPC, professional. I actually don't know what RPC stands for. Violating the RPC or assisting others in doing so. Rules of professional code, sorry. How did I get that mess up? Rules of professional conduct or assisting others in doing so. Committing a criminal act that reflects adversely on a lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Stating or implying an ability to improperly influence a government agency or official or to achieve results by means that violate the RPC or other law. Conduct involving dishonesty, fraud, deceit, or misrepresentation, even outside the practice. Conduct prejudicial to the administration of justice. Knowingly assisting a judge or judicial officer in conduct that violates the JC or other law. Certain discriminatory acts in the course of practice. Creating, terminating. So those are the 7 types of conduct that will subject a lawyer to discipline. Violation of RPC, criminal act, bearing on honesty, trustworthy, fitness, stating or implying ability to improperly influence, conducting oneself fraudulently, misrepresentation, dishonestly, being prejudicial in the administration of justice, assisting a judge in basically violating CJC rather than RPC, and certain discriminatory acts in the course of practice. Part 3, creating and terminating a lawyer-client relationship. How is a lawyer-client relationship created? By express agreement, implied agreement, look for reasonable reliance by the client. Lawyer is appointed by a tribunal is the 3rd type of way that a client-lawyer relationship is created. Scope and bounds of representation. The lawyer may reasonably limit scope of representation with informed consent. The client always has final decision with respect to settlements, pleas, whether to waive jury trial in criminal case, and whether client will testify in a criminal case. Acts within bounds of the law, must withdraw if the client is using lawyer services to commit a crime of fraud. So what are the scope and bounds of representation? Just like reviewing those twice. The lawyer may reasonably limit the scope of representation with informed consent, and the client always has the final decision with respect to settlements, pleas, waiver of jury trial, or testifying in a criminal case. And the other scope and bounds is that the lawyer must act within the bounds of law and withdraw if the client is using their services, the lawyer's services, to commit crime or fraud. Establishing compensation for legal services is Part C. There's a duty to avoid fee misunderstandings. A and B, a lawyer must communicate the basis or rate of the fee and any expenses for which the client is responsible, but doesn't have to repeat the same information if the client is regularly represented in the same type of matter. That's like your retainer. A written fee agreement is preferable, but generally not required. In California, however, a written fee agreement is required if the fee will exceed $1,000, but this is subject to various exceptions. The client is a corporation. The client doesn't want a written agreement. The fee is the same as in a prior matter for the client, emergency or impracticability. Fees must be reasonable based on various factors. That's the second part of establishing compensation for legal fees. One, to avoid misunderstandings. You've really got to communicate the basis of the rate of the fee. You really need to write it, especially in California, unless there's these rare exceptions that it will not exceed $1,000, or your corporate client, an emergency or impracticability, or the client is literally asking you not to write an agreement, or it's like happening so frequently that you've already represented the client for this exact same thing. But so 2 is the fee must be reasonable based on the various factors. That's true, but in California, unconscionable or illegal fees are not permitted. Advance payments are allowed, but unearned portion must be refunded if the lawyer is fired or withdrawals. But a true retainer paid solely to ensure the lawyer's availability may be non-refundable. Contingent fee agreements must be in writing and signed by the client and include very specific disclosures. A contingency fee is prohibited for criminal cases or domestic relation matters unless the representation only involves collecting past due balances on financial orders. Fifth, within the section of establishing compensation for legal services, is that true referral fees between lawyers are not allowed, but lawyers in different firms may divide fees with clients' consent if the fee is proportionate to the work performed by each lawyer, or if each lawyer assumes joint responsibility for the representation. California referral fees generally permitted with the client's consent, regardless of referring lawyer's involvement. Mandatory withdrawal 1, 2, 3, and 4. Continued employment will violate RPC that mandates a withdrawal. 2, the lawyer's physical or mental condition materially impairs their ability to represent the client. 3rd, the client discharges the lawyer. And 4th, in California, the lawyer knows that the client is acting without probable cause and to harass or maliciously injure another person. Permissive withdrawal. The ABA and California rules recognize various grounds. This is where conflict of interest comes up. And that could be among a prospective client and your existing client, prospective client and your former clients, perhaps dual representation, or a prospective client and your own interests, or interests of someone like in your immediate family, or for some reason you wouldn't be able to provide zealous representation of your client. Protecting the client's interests on termination. Examples include returning the client's papers, allowing the client time to secure other counsel, and refunding unearned fees. Interestingly, you do have to apply to withdraw with the court. Not written here, but that would be something you have to do on termination. Part 4, if applicable. Part 4, protecting clients' interests in property. A, protecting the client's information. B, duty to protect the client's funds and other parties' property. So there's really only A and B within protecting clients' interests in property. So I'm going to run through these 2 parts. One is the attorney-client privilege. The other is the duty of confidentiality. ACP applies to testimony in court by a lawyer or client regarding confidential communications. It survives termination of relationship and client's death. California privilege terminates when client's estate is settled and the personal representative is discharged. For organizational clients, the privilege applies to communications with a high-ranking official or other employees who speak to the lawyer at the discretion of a superior about a subject within the scope of the employee's duties. And duty of confidentiality, broader, applies to any disclosure of any information relating to the representation. Duty continues to apply after the relationship has terminated and client's death. ABA and California recognize various exceptions to the rule. California duty of confidentiality is stronger. Disclosure permitted only to the extent reasonably necessary to meet the exception. Duties to protect clients' funds and other property. Must keep clients' funds in a separate trust account. May deposit personal funds to pay bank service charges only. Must place advance fees in the account to be withdrawn as fees are earned. Must notify the client or third person upon receipt of funds, property in which client or third person has an interest. Third, must maintain records of client account funds dash property. Must deliver funds dash property on client's request and provide an accounting. If the lawyer possesses disputed funds or property, the disputed portion must be kept separate by a lawyer until the dispute is resolved. Part 5, avoiding conflicts of interest, your general principles, your conflicts with current clients, the general rules, specific current client conflict situations, some permitted if requirements are met, some are always prohibited, conflicts in representing an organization, conflicts with former clients, conflicts with prospective clients, conflicts related to government work, and prior involvement in a matter as judge or third party neutral. This is going to be it's going to be like 4 pages. So, for the general principles, the lawyer owes a duty of loyalty and must avoid conflicts of interest. The lawyer's conflict is imputed to other lawyers in the firm unless the conflict is based on personal interest and would not materially limit the other's representation. Some imputed conflicts based on disqualified lawyers' prior dealings, including representations, employment, government work, consultations with prospective clients, etc., can be overcome with screening and notice procedures. Conflicts with current clients' general rules. When a conflict exists, A, direct adversity between clients, or B, a significant risk that the representation will be materially limited by the lawyer's personal interests or by lawyer's duties to another client, former client, or third person. Lawyer may still accept representation if the lawyer reasonably believes he can competently and diligently represent each client. The representation is not prohibited by law, and the representation does not involve a claim by one client against the other, and each client gives informed consent confirmed in writing. California requires the informed written consent, meaning that both the disclosure and the consent must be in writing. Additional California provisions regarding the lawyer's relationships. In California only, the lawyer must provide written disclosure to client of certain relationships with a party, witness, or attorney in the matter, despite a relationship not creating a significant risk of material limitation. If there is a significant risk of material limitation, the usual informed written consent is required. Part C, specific current client conflict situations, some permitted if requirements are met, and some are always prohibited. There are like 10 enumerated provisions in this section. Business transaction with pecuniary interest adverse to the client, using confidential information to a client's disadvantage, substantial gifts from clients, soliciting the gift or preparing the instrument, providing financial assistance to the client. In California, more flexible about providing loans to clients. 5th, accepting an aggregate settlement on behalf of multiple clients. 6th, accepting compensation from a third person. 7th, prospectively limiting malpractice liability or settling an existing malpractice claim, accepting literary or media rights based on information relating to the representation. California has no specific rule, but must meet the requirements of pecuniary interest adverse to the client. Proprietary interest in the cause of action. California, no specific rule, but must meet the requirements of pecuniary interest adverse to the client. In this, number 9, proprietary interest in cause of action. 10, engaging in a sexual relationship with the client unless the relationship existed before the representation started. This is not imputed to others at the firm. Part D, conflicts in representing an organization. 1, a lawyer must act in best interest of the organization. 2, reporting violation of a legal obligation or violation of law by someone associated with the organization. Reporting. A, reporting to higher authority inside the organization, generally required if the violation is likely to result in substantial injury to the organization. B, outside reporting. If the highest authority fails to take action, the lawyer may report to an outside authority if necessary to prevent substantial injury to the organization. even if the disclosure would be prohibited under the duty of confidentiality. In California, however, outside reporting is prohibited unless an exception to the duty of confidentiality applies, in which case the lawyer may withdraw instead. Conflicts with former clients. A lawyer must not represent someone adverse to a former client in the same or substantially related matter, absent former client's informed consent confirmed in writing. A similar rule for opposing client of former firm in same or substantially related matter. Part F. Conflicts with prospective clients. A lawyer who consults with a prospective client in connection with a matter in which he participated personally and substantially as a government employee, unless the government agency gives informed consent confirmed in writing. Matter must involve specific facts and parties. Drafting general legislation would not qualify. And current government lawyer must not participate in a matter in which she personally and substantially participated in during private practice. Usually, government agency provides informed consent confirmed in writing. And third, current government lawyer who is participating personally and substantially in a matter must not negotiate for private employment with a party or lawyer in the matter, exception for law clerks. And H, the final section in the conflict of interest section, is prior involvement in matter as judge or third party neutral. Former judge, mediator, or other third party neutral in a matter must not later represent anyone in that matter unless all parties give informed consent confirmed in writing. Competence, diligence, and communication. This is part 6A. Basic obligations of competence and diligence. Competent representation requires legal knowledge, skill, etc. A lawyer may gain competence with adequate research or preparation or by consulting another lawyer and must act diligently in the client's interest. In California, the lawyer only subject to discipline for intentional, reckless, grossly negligent, or repeated failure to perform legal services competently or diligently, generally not subject to discipline for isolated or minor mistakes. And B, duty of communication. 1, the lawyer must tell the client about all significant developments, such as settlement offers, and must comply with reasonable requests for information. Part 4, the lawyer as a counselor. There's 3 types here. Duties of the lawyer as an advisor, as a third party neutral. This middle one, creating evaluation for client. The lawyer may prepare evaluation on client's behalf for use by a third person, but must get client's informed consent if it will materially harm the client. Duty as an advisor, exercising independent judgment and render candid advice. Duty as a third-party neutral, the lawyer acting as mediator, arbitrator, etc., must inform all unrepresented parties that he does not represent them and must clear up any misunderstanding about his role. And he really can't take a client afterwards from this mediation. Lawyer as advocate, I think it would create a conflict of interest. It says here, former judge, mediator, or other third-party neutral in a matter must not later represent anyone in that matter unless all parties give informed consent confirmed in writing. So you could, but you need to document it all. Lawyer as advocate, respecting the court's time, candor towards the tribunal, fairness to opposing party and counsel, preserving impartiality of tribunal, trial publicity, trial counsel as a witness, advocate in legislative or administrative proceedings, and special duties of public prosecutors. That is going to be another 2 pages of details in the lawyer as advocate section. Part A, respecting the court's time. No frivolous claims or contentions can be brought. A lawyer must know that they are bringing a good faith argument and must make reasonable efforts to expedite litigation consistent with client's interests. In California, there is no duty to expedite, but must not use means that have no substantial purpose other than to delay or cause needless expense. Candor towards the tribunal, Part B, 1, 2, 3, and 3A. 1, a lawyer must not make false statements of fact or law to the court or fail to correct materially false statements. 2, must not knowingly fail to disclose directly adverse controlling legal authority if opposing party failed to do so. 3, must not knowingly offer false evidence. Special procedures for criminal defendant client who wants to lie on the stand. but there's a 3A, must also mitigate false evidence with reasonable remedial measures, which may include disclosing confidential information to the court. In California, reasonable remedial measures must not involve revealing information protected by duty of confidentiality. So let's just read this one more time, because I do feel that this gets, or at least I've been confused in the past. The lawyer must not knowingly offer false evidence. But in parentheses, it says there are special procedures for criminal defendant clients who want to lie on the stand. That's all you're going to get on that topic in this outline. Fairness to opposing party and counsel, 1 through 5. 1, a lawyer must not obstruct the opponent's access to evidence or falsify evidence or assist in perjury. Payments to witnesses are as follows. For fact witnesses, reasonable travel and incidental expenses may be paid. Reimbursement for loss of time may be paid. For experts, payment of a reasonable fee, but must not be contingent or content or outcome. 4th, a lawyer must not violate a court rule or order except good faith challenge. And 5th, when representing a client in a civil case, a lawyer must not threaten the disciplinary, criminal, or administrative charges for the purpose of obtaining an advantage. Part B, preserving impartiality of tribunal, 1, 2, and 3. A lawyer must not try to influence a judge, court official, juror, or prospective juror by improper means. No ex parte communications with judges, court officials, jurors, or prospective jurors during the proceeding. May interview jurors after discharge unless they don't want to talk or it involves misrepresentation and coercion, etc. Part E, trial publicity. The lawyer must not make extrajudicial statements likely to materially prejudice an adjudicated proceeding, but may reply to protect a client. Trial counsel as witness. A lawyer may not represent the client in a matter in which she is likely to be necessary witness unless A, B, or C, uncontested issue. B, testimony involves the nature of and value of legal services. And C, withdrawal would result in substantial hardship. In California, instead, allows the lawyer to act in a dual role with the client's informed consent. Part G, advocate in legislative or administrative proceeding. A lawyer may present evidence or argument on a client's behalf at an official hearing or meeting, but she must disclose that she is acting in a representative capacity, need not identify the client. H, special duties of public prosecutors. 1, must avoid bringing charges not supported by probable cause, must make timely disclosure of exculpatory evidence to defense. And 3rd, additional duties to disclose and or remedy false convictions even if not involved in the case. Dealing with non-clients, this is subsection 9. There's A, B, C, and D under this. Oh my gosh. Did I say dealing with non-clients, or did I say, yeah. Communication with represented person, communicating with unrepresented persons, truthfulness in statements to others, receipt of documents sent by mistake. 1, in communicating with represented person, lawyer must not communicate with a person known to be represented by counsel unless the person's counsel consents or the communication is authorized by law. A, the rule also prohibits contact with certain employees, members of represented organizations, generally high-level employees and employees who committed the acts at issue in the matter. B, communicating with an unrepresented person. A lawyer may communicate with an unrepresented person, but must not act as if disinterested. And 2, if the person's interests conflict with the client's interests, no legal advice may be given except telling the person to obtain counsel. And C, truthfulness in statements to others, no false statements of material fact to third persons, but puffing your client's position is allowed. And D, receipt of documents sent by mistake. Must promptly notify sender of a document or electronic information relating to representation that is inadvertently received. In California, you must refrain from examining the writing any more than necessary to determine that it is privileged or subject to work product doctrine. The practice of law, subpart 10. A, admission practice. B, unauthorized practice of law. C, duty, train, and supervise. D, responsibilities of a subordinate lawyer. E, professional independence of the lawyer. F, arrangement restricting the lawyer's right to practice. G, sale of the law practice. H, law-related services. Before we get to marketing legal services, it's the second to last penultimate section. So let's go through these. A through H, practice of law. Admission to practice. Applicant must show good moral character, must not make false statements or fail to correct misapprehension regarding own application or someone else's application. Unauthorized practice of law. 1, a lawyer must not engage in or assist someone else in unauthorized practice, for example, appearing or negotiating on the client's behalf, providing legal consultation. A, may delegate tasks to non-lawyers, but must be ultimately responsible for results. California specific rules for employing a disbarred or otherwise ineligible lawyer. And 2, a lawyer cannot practice in a state where she is not licensed except permissible. Temporary practice, pro hac vice, associating with an active local lawyer, mediation arising out of home state practice, and permissible permanent practice. 1, lawyer employed by client only, i.e. in-house counsel. 2, practice in restricted branch of law, for example, federal agencies. Duty to train and supervise. All partners, managers, and supervisors must make reasonable efforts to ensure that actions by lawyer and non-lawyer subordinates conform to the RPC. A lawyer responsible for another lawyer's or non-lawyer's act if she A, orders or ratifies the act. B, supervises or manages a person and knowingly fails to make remedial action. D, responsibility of subordinate lawyer, must follow RPC even when acting at supervisor's discretion, but can safely follow supervisor's directions regarding the reasonable resolution of an arguable question of a professional duty. So, arguable question of a professional duty, resolution of which. What does that do? That's something that the subordinate lawyer can follow if the supervisor's directions regarding a reasonable resolution of an arguable question of professional duty are sought, you can execute on them without compromising yourself. Professional independence of a lawyer. 1, no partnership with non-lawyer that involves legal practice. So you can't start a practice like with an accountant or at this time. Non-lawyer must not own an interest in a law firm or have any right to direct or control professional judgment. So that accountant can't own any of your legal practice or direct or control the lawyer's professional judgment. Generally, must not share, so a lawyer must not share legal fees with non-lawyers, subject to a few limited exceptions. So those exceptions will be like, so-and-so died in our practice, and now you're going to give like their spouse some unearned fees or something later when the practice earns them. When they're earned. F, arrangement restricting lawyers' right to practice. Partnership employment agreements that restrict the lawyer's right to practice after termination are prohibited, except agreements for retirement benefits. And a lawyer must not enter into a settlement agreement on the client's behalf if the agreement limits the lawyer's right to practice. Sale of a law practice. Entire practice or field of practice must be sold. California, all or substantially all of the practice must be sold. You can't sell just a field of practice. If you have 2 fields within your practice, you have to sell it all in California rather than just one part of it. The seller generally, whereas for sale of practice, the entire practice or field of practice must be sold. So, or what? Like, I think this following on the arrangement restricting the lawyer's right to practice, I think is building on that, but it's like a separate section. But I think what they're trying to say is like can sell your practice, and in so doing, engage in a right not to compete with the buyer of your practice. So it says here too, the seller generally must stop private practice in a geographical area. The seller in California, the seller is not required to stop practicing law in a geographic area, but parties may choose to enter into a reasonable non-compete agreement. And third, fees to clients must not increase as a result of the sale. And fourth, must give written notice to clients and provide opportunity to retain other counsel or collect their file. H, law-related services. Lawyer is subject to rules of professional conduct with respect to non-legal services if the services are provided under circumstances that are not distinct from the legal services. In California, there's no counterpart rule. Marketing legal services is Section 11. A, communications about a lawyer or legal services. 1, ads and other communications must not be false or misleading. In California, additional statutory restrictions on advertising content. A, under this false or misleading prong, unfounded conclusions, unjustified expectations of results, and unsubstantiated comparisons to other lawyers are all misleading. 2, a lawyer can say what fields of law she practices in, but must not claim to be a certified specialist unless actually certified by an approved identified organization. 3rd, even firm names might be misleading, for example, a trade name that implies a connection with a government or charitable agency. I saw one of those recently on a business card and did say something about it, but also didn't know what I was talking about. Anyway, paying for recommendations. 1, prohibited except A, costs of permitted advertising, B, charges for legal service plan or nonprofit lawyer referral service, C, paying to purchase a law practice, D, reciprocal non-exclusive referral agreements with another lawyer or non-lawyer professional, and E, isolated gifts or gratuities as a token of appreciation. C, solicitation, in-person, live telephone, or real-time visual or auditory electronic solicitation prohibited if motive is pecuniary gain. A, prohibition does not apply to certain persons who are less vulnerable, for example, lawyers' family members. 2, targeted direct mail solicitation, including email, recorded message, etc., generally are allowed. 3, may not solicit any person by any method if A, the recipient has indicated a desire not to be contacted, or B, the solicitation involves coercion, duress, or harassment. And 4th, must not use an agent to do what the lawyer is prohibited from doing. This is the last section, the lawyer's responsibilities to the legal profession. There is public service, statements about judicial and legal officials, and reporting professional misconduct. So I'm going to start here. A lawyer must report a lawyer who has violated the rules of professional conduct if violation raises to a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. However, in California, which is why I brought up the business card thing, there's no counterpart rule requiring lawyers to report other lawyers. Instead, lawyers must self-report when certain events occur. For example, they're convicted of a crime or disciplined in another jurisdiction. Also, you must not enter into any agreements that inhibit someone from filing a discriminatory complaint. I guess I will read this. So for public service under the lawyer's responsibilities to the legal profession, 1, pro bono service is not required, but an aspirational goal. 2, a lawyer must not seek court appointments except for good cause. 3rd, a lawyer may participate in a quick program sponsored by a nonprofit organization. The rules of professional conduct apply to those services, but the conflict of interest rules are relaxed. That's nice to know. 4, may serve as a director or member of a legal services organization, but may be prohibited from practicing in a decision that involves a client. And 5, may participate in law reform activities, even if a decision could materially benefit the client, must disclose the fact, but need not identify the client. California has no equivalent rule. 1, must not make false or reckless statements about the qualifications or integrity of a judge, public legal official, or candidate for judicial or legal office. That's the statements about judicial and legal officials section. So you can't make false or reckless statements about a judge's qualifications or another public legal official or candidate for judicial or legal office. Now, I already read reporting professional misconduct, and that's everything in the BARBRI's overview for professional responsibility.